Appeals Division 1 is now in session.
Please be seated. Good morning, Council. Court now calls case number JV140243, in re Maribel R. This is the time set for oral argument. Council, let me advise you that these proceedings are being audio and video recorded, and the proceedings will be available on the court website in a few days, so be aware of that. Please identify yourself during your argument and your client. You have 20 minutes to present your argument. Counsel for appellant, you can reserve time for rebuttal as well. We've read the briefs, we've conferenced the case, we're very familiar with the issues in this case, so keep that in mind. And you have a clock on the podium in front of you to keep track of time. Counsel? Is it Mr. Breger?
Yes, Breger.
Breger? Okay.
May it please the court. My name is Kevin Breger, and I represent Maribel R., who is actually present in the courtroom this morning.
Mr. Breger, can you, off the top, explain how you can challenge this requirement now when there was no appeal from the initial imposition of it?
Yes, Your Honor, certainly.
Doesn't that waive it?
I don't believe it does, and I think there are a number of significant reasons as to why that's the case. I think the one significant reason is the argument that we've put forth with regards to the ineffective assistance of counsel. If Maribel was properly advised with regards to the appeal issue, if Maribel's attorney at the time of the hearing in question properly put forth the relevant arguments and the relevant law, she could have made a better informed decision and likely would have appealed, as is substantiated by her affidavit that was filed.
So beyond that, your position is that somehow the initial imposition of this requirement was not legally authorized?
Yes, Your Honor.
In the plea agreement, is there not a specific reference to 13-118 and all kinds of discussion throughout the course of the case of, there being a psychosexual evaluation, and wasn't it all along understood that this was a sexually motivated crime, even though it was called disorderly conduct?
There was no. The state didn't even reference that in their argument, and I think there's a good reason that they did not, because 13-118 specifically provides for a mechanism by which registration, etc., could be imposed even for a non-sex type case. There specifically has to be a filing by the state of a special allegation of sexual motivation, and then the record would need to suggest that there's been established beyond a reasonable doubt that the defendant committed the offense with a sexual motivation, and there wasn't anything of that nature on the record. I believe even the factual basis that underlied the disorderly conduct did not have anything in it to substantiate the necessary information with regards to that.
There's a lot of other stuff in the record that would substantiate it, right?
I respectfully disagree, and I think that the state didn't take that position, and I think the reason they didn't take that position is because they were of the mindset that the trial judge's basis for ordering the registration in the first place was not actually based on the second petition where she pled to the disorderly conduct, but it was actually based on the first petition where she had successfully concluded her probation, where probation had been terminated successfully, and based on that, the court had actually lost jurisdiction over her. So our position is that based on ARS 8202G, which specifically states, except as otherwise provided by law, jurisdiction of a child that is obtained by the juvenile court in a proceeding under this chapter, it goes on to state that shall be retained by it for the purposes of implementing the orders made and filed in that proceeding until the child becomes 18 years of age, unless terminated by order of the court before the child's 18th birthday. And Maribel R. did successfully conclude probation. She successfully completed her sex offender terms at that time. So our position is that any legal basis to justify ordering of registration was concluded and effectively closed off. And the new case was not a legal basis for the registration requirements at all. And that's, I believe, why the state did not argue that in their reply.
You're saying that the offense that she pled to, the disorderly conduct, was not the offense that involved a sexual offense?
Judge, the underlying case, the first offense that she was on probation for was a sexual
Right.
offense. The second offense was charged as, I believe, a molest, but it was pled down to a disorderly conduct, quite frankly, because the state just didn't have a strong enough case to proceed. So they compromised and pled her to a disorderly conduct, which was not a sex offense.
Well, why did the state put 13118 in the plea agreement then? That's the sexual motivation statute. Why is it in the plea agreement that your client initialed acknowledging that she was pleading guilty pursuant to that statute? And were you the trial counsel as well?
I was not.
Okay, trial counsel signed that plea agreement, and so did the prosecutor. So you're telling me that nobody paid any attention to the sexual motivation statute? Isn't that what this plea agreement is?
I think what overrides the issue with regards to the plea agreement is the fact that the language in paragraph 2 of the plea agreement specifically talks of I believe registration may be, or sex offender terms of probation may be imposed. I believe that's the language in paragraph 2. And I think in the mind of Maribel R. as well as her counsel, that overrid the reference to the...
I'm having trouble following that, counsel. It says a special allegation. I mean, arguably, the fact that the count is amended to include 13118, it's now an amended indictment, so it's now been alleged. Isn't that the effect of as amended in the plea agreement, is that you're amending the indictment to this charge, right?
Correct.
Or the
So-
complaint.
Maybe it was a felony complaint, whatever your petition, I'm sorry, in juvenile court. So it has been amended, it has been alleged. Your client pled guilty pursuant to 13118. And then in paragraph 2, the plea agreement specifically talks about maybe the court has the discretion to have sex addendum terms imposed, and that your client will participate in a psychosexual or sexual risk assessment. I'm not seeing how this is overlooked. I mean, there's an initial right next to paragraph 1 and paragraph 2, signed by your client, initialed by your client. How is this something that wasn't addressed and wasn't paid attention to by the parties down below?
Well,
Or the
that
court, for that
Yeah,
matter?
accepted by the court.
At a change, I assume there's a change of plea proceeding and that this was gone through and...
Well, the one issue is that perhaps trial counsel should have dealt with that more appropriately and argued that more appropriately for her. I think the more important aspect is that although the statute is in general terms referenced in the plea agreement, the statute is very clear, and it requires the state to file a special allegation of sexual motivation. There was no such document specifically filed on the record, nor is there anything on the record to suggest that there was that they proved beyond a reasonable doubt that the offense was committed with a sexual motivation.
But by amending the petition and adding it and then ostensibly discussing it, it's not as if you plead guilty and then you've got these defenses to raise. Those are essentially waived as a result of the plea agreement.
I respectfully disagree. I don't believe just referencing the statute in the plea agreement waives the additional requirements that the state would have to take.
You don't have a separate ability to, as used to, then try to undermine the plea agreement once you've waived your rights.
Counsel, I think you're talking about a situation where if this case had gone to trial and it wasn't ever alleged in any type of special, notice or in the original petition, I think I would agree with you. But the plea agreement amends the charging document, and so why you would have the notice, in fact, that's right in the plea agreement. It's standard language in paragraph 4. It says, this written agreement amends the petition.
It says that the disposition will be on the charges listed above without the filing of any additional legal documents. And that includes 13-118.
And then beyond that, I think it's 133821C that talks about the types of offenses that are discretionary for a court to impose registration. The mandatory crimes are in 133821A. By pleading and amending this with 13118, the court was squarely within its discretion, wasn't it, under 133821C, to impose sex offender registration? On this case, I'm not talking about the 2010 case. I know your client completed probation, was discharged from probation. I'm talking about the 2012 case. You don't agree?
I disagree respectfully, Judge. Once again, I believe that the proper requirements of 13118 were not met to go beyond that threshold. In addition to which, although the statute is generally referenced, the disorderly conduct is not specifically one of those types of crimes that's referenced in that statute. So our position is that there was no legal basis to order the registration with regards to the second offence either. So, having said that, this court absolutely does have jurisdiction with regards to remedying the issue and resolving the injustice with regards to Maribel R. Because of the ineffective assistance of counsel with regards to properly advising her, properly arguing for her, properly...
What would he have properly advised her of?
Her rights with regards to registration. There was argument. It wasn't just a fait accompli that she was going to register. There was a hearing to determine whether she was going to register, and there was argument back and forth and discussion back and forth on the record as to whether she should be ordered to register or not.
Did the lawyer not make the proper arguments against it?
No, Your Honor. Respectfully, the attorney did not make all the proper arguments.
Well, how was he deficient?
He was deficient because he did not properly argue. There was a lot on the record to suggest that the underlying reason as to why the registration was ordered in the first place was based on the original charge, and she did not argue effectively that there was no legal basis to order the registration. There was discussion on the record by all the parties, including the trial judge, that there was a mechanism to remedy the situation, that Maribel could have not appealed, but had a review in a year's time to determine whether she should still be required to register or not. And there was a discussion, and all the parties seemed to agree that that was a legitimate mechanism, including her counsel.
I mean, I know the state is saying there's no jurisdiction, but I mean, are you saying there's something wrong with that review mechanism?
I'm saying that review mechanism does not apply to a juvenile adjudicated delinquent out of the juvenile court. Had the juvenile case been transferred to the adult court, and had she been...
I don't follow that. Now, Division 2 has just written an opinion that I read to say that a juvenile court which has authority by statute to impose sex offender registration has implied authority to undo it. You're aware of that case?
I'm not familiar with that case, Your Honor.
It's called Nicholas T. So, I mean, if the judge had the authority to undo it, if the judge determined that there was no longer any need for the registration requirement, then there wouldn't be anything wrong with the notion of reviewing the thing in a year.
Maribel R. did try and get a review, and that's what precipitated this whole appeal process. She went back in front of a juvenile court commissioner. It wasn't the same judge that ordered the registration in the first place, and she tried to have that commissioner reverse the registration, and he blankly shot her down and said that he did not have the authority to do so, and he appointed counsel for her to file an appeal on her behalf. And that's really the first time that she became aware that there was an issue with regards to registration, and hence here we are today.
One of the issues we may well need to address is to let people know about the Division 2 case, and that really if a juvenile prior to age 25 has no other recourse, the juvenile court has to put on its superior court hat and act to either grant or deny, but on the substantive basis, as opposed to saying, you know, you're over 18, I can't do that. Okay.
So in addition to the ineffective assistance of counsel, the representations made on the record by the trial judge to suggest that she had this remedy, when a year down the road she came back to find out she did not have such a remedy, she really has nothing else to hang her hat on.
Apart from the procedural claims you're making, why should, I mean, if you look at the merits of her application, why should she be relieved of this obligation?
She did successfully complete her treatment when she went back to the commissioner a year down the road and was shot down and told that the registration could not be reversed. So she complied with everything that she was obligated to do. She complied with the treatment originally for the original offence that the record would suggest was the basis for the registration. So she had jumped through all the necessary hoops and had successfully moved on with her life. And that's why she was coming back, as she was advised to do by the trial judge and by her attorney. She was advised, once she had done everything she needed to do, to come before the court again and seek the appropriate remedy, which in her mind, at the age of 17, when she was told all of this, was to reverse the registration requirement. So she felt that she had done that. She had successfully moved on with her life. She's been a law-abiding citizen otherwise. She has been complying with the registration requirement. So she, in her mind, for good reason, believed that she had done everything that needed to be done.
And how old is she now?
She, I believe, is 18 or 19, I believe.
19,
And there's a severance case pending right now, or there's a dependency?
I'm not familiar with that, Your Honor. I'm not involved in that side of the case at all. If I could reserve the balance of my time, please, Your Honors.
Okay.
Thank you.
Anything else? All right, counsel?
May it please the court, my name is Catherine Leach. I represent the state in this case. And may I say first off, if I could go back and rewrite my brief, I would, but I'd like to address the points that are raised here rather than that. First of all, I've been confused for a time about what the issue is in this case, because ostensibly the juvenile was appealing from the juvenile court's order that it had no jurisdiction to review the order to register. But that's not what's being appealed here. What's being appealed, as the court has noted, is the original disposition for this case itself. Now, the way this court would have jurisdiction to do that is through Juvenile Rules of Procedure 108B, which provides for a delayed appeal. However, there's a process for that, which the juvenile in this case has not followed.
And would that allow potentially a delayed appeal on the basis that the juvenile did not appeal because of deficient advice from counsel?
It provides for an appeal, depending on the presiding juvenile judge approving it, based on the fact that the juvenile did not appeal was due to excusable neglect. So,
And there is no concomitant to Rule 32 post-conviction relief proceedings in juvenile court.
there is not. So a delayed appeal would be the only way to go in this case.
If this were a criminal case, that would presumably would be how she would raise the deficient.
And in fact, she would have no choice but to raise it under Rule 32. Under juvenile, there's no such right. So then the question under 108B would have become, was this excusable neglect, which could be argued, but of course hasn't been, because she never made application to the presiding juvenile judge. So it doesn't appear that we're here on either appropriate procedure. She's not appealing the order she appeared to be appealing from, and she did not get permission to file a delayed appeal through the mechanism provided. However,
It seemed that the issue presented was the propriety of the initial imposition of the requirement.
exactly, and I'd like to address that next. As the court has already observed, there really wasn't any question in this case that the crime she pleaded to was sexually motivated. And I say that because, as the court has already noted, the plea itself, the plea agreement itself provides that when she entered it, she waived all previous defenses, objections, whatever, that she had to anything that happened before the plea agreement. So she waived any formal requirement that the state file a notice of 13118 sexual motivation.
Well, besides, I mean, there was a full hearing on this issue, right? It's not like she went to the hearing and didn't know what the hearing was about.
Well, and not only that, but it was
Certainly
discussed.
the purpose of this filing is to give the person notice that this requirement is being sought.
Well, and it was discussed 2 times. First of all, well, maybe 3. In the change of plea proceeding itself, which the transcript is on the record, the sexual motivation, the sexual components of the crime were discussed to some extent. But more importantly, it was discussed extensively in the disposition hearing when the discussion was, as you say, the psychosexual evaluation, which part of which actually, well, the psychosexual evaluation was ordered at the plea and took place before the disposition. So everybody knew at the plea and nobody objected that that was part of what the court needed to see for the disposition itself. Was, or did the psychological expert believe that it was a sexually motivated crime, and you know, what consequences could or should follow from that. So they had that. That was understood at the time of the change of plea, if not before. At the time of the disposition, there was a long discussion about what the psychological expert had said. The appellant's attorney at that point argued that regardless of what the psychosexual evaluation said, that it was not sexually motivated, that sex offender terms should not be imposed. So yes, there was full notice. There was really, and I suspect this is why the appellant's juvenile attorney did not appeal at that time, because there was no basis. There was no denying at that point that everybody knew this was a sexually motivated crime. And I would like to interject. I did talk to the juvenile prosecuting attorney before I came in here today.
Is that in the record?
No.
It's not in the record.
It's all right. So it's a disorderly conduct for reasons which are not in the record. However, it's sexually motivated, and that is the basis for the disposition. Now, one of the things that the appellant has argued here is that, well, sex offender terms could be imposed under the plea agreement, but only if she was put on probation. But I would point out, as I'm sure the court is aware, registration is not a term of probation. It can be included as a term of probation, but it's not a term of probation. It's an entirely separate statute. And people who go to DOC as adults and people who go to DOC as juveniles can be required to register, probation having nothing to do with it.
Does the expression was sex addendum terms may be imposed.
Yes,
Does that
exactly.
include the registration status?
Well, this is the argument that the appellant has made. My argument would be if the sex offender terms were added as an addendum to probation, they could have included sex registration as a part of that addendum. That has nothing to do with whether she could be ordered to register entirely separately from sex offender terms on probation. She was sent to DOC. The fact that she was not given probation does not in any way have an effect on whether she could be ordered to register under 133821 and 13118. Those are entirely separate from probation itself. Now, I'd like to point out here, I was not aware of the case that the court just cited, the Nicholas T. case out of Division 2. It had appeared to me that perhaps there was no mechanism for review of the sex offender registration based on Espinosa, which pretty much says once the juvenile has turned 18, the juvenile court has lost jurisdiction to review its own orders in juvenile court.
And I'm not going to ask you to concede away your jurisdictional argument, but let me give you just a couple of clues that I have that suggest that a juvenile judge could undo the requirement imposed on a juvenile in juvenile court. For one thing, there's this Division 2 case that implies that the authority to impose the requirement also allows the requirement to be relaxed or omitted later when there's a showing that's no longer needed. But there are several provisions that we found. For example, the fact that the sex offender registration status goes to age 25. If truly there were no jurisdiction, how could a juvenile court's order extend beyond age 18? And it does by statute.
Well, I believe that's actually addressed in a number of cases, and the one I'm chiefly relying on is Espinosa. The problem with Espinosa is it says uncategorically the juvenile court has no jurisdiction over its cases or over its orders imposed in a juvenile case once the juvenile reaches 18.
Now, let me give you another clue, though. There's a provision that it's not applicable here, but it's 13-912.01. A person who's adjudicated delinquent may petition the juvenile court for restoration of the right to possess or carry firearms, but for certain violent offenses can't do it until age 30. So that would seem to specifically allow, at least in that case, for the juvenile court to have some lingering authority over some former juveniles.
Well, I'm not sure in that case that the person who had now turned 30 would apply to the juvenile court. However, I agree
Statute seems to say.
that it would apply to the juvenile court for restoration.
Well, what would happen is the court would take off his kid hat and put on their superior court hat.
And yeah,
You don't have to go to the adult court in downtown, the South Tower, when the record is contained within a portion of the superior court. They could deal with the issue.
Well, then that would be the solution. I hadn't really looked at that statute either.
Well, of course, we're aware of the general notion that the juvenile court's authority over a juvenile ends when the child turns 18. There seems to be these little areas of lingering authority that we're trying to grapple with, I guess.
Well, and I don't think the question of restoration of that particular right was discussed in any of the cases I was looking at, because that's exactly what I was looking for, is there a possibility? And it seemed in the cases I was reading that there was not, which obviously the flaw in that case would be, then how do you have these things reviewed if that need should arise? So, and I'm not saying the court's wrong about that. That would seem that there has to be some mechanism to have these things reviewed. You can't just be left with them.
That's the upshot of Judge Portley's comment, is that it seems like, at least according to the Division II opinion, somebody has to be able to make this determination because it's implicit basically in the judicial function.
Well, certainly in that case, in that statute it is. I guess my
But
thought.
again, I mean, like you commented, it doesn't seem like we're really here to discuss the propriety of the judge or the commissioner in his or her discretion denying this application for relief from the registration requirement. The question presented in the appeal seems to be the propriety of the initial imposition of the requirement.
Well, and 108B is not clear exactly what the procedure would be for requesting a delayed appeal. Again, analogically speaking, in a PCR case, you would have a hearing at the trial court level to deal with the issues.
Besides, wouldn't you have the same jurisdictional question? I mean, if in fact the juvenile court loses authority over kids when they turn 18, does it have authority to grant a delayed appeal to a person who's now an adult?
Well, that's the other question, but
Begging.
it is a question, and then I think at a certain point the issue of waiver also comes up. But I looked for annotations under 108B, and there isn't anything, so there may be a case of first impression. What I thought of was, if you go under 108B, the juvenile could be, say, ordered to register, in this case, shortly before she's 18, but say the day before she's 18. And if there were an appealable issue there, and she turns 19 the next day, then if 108B did not allow for an appeal in that situation, then 108B would be virtually meaningless, unless there were enough time for the appeal to be heard.
It's not through the age of 18. It stops at midnight on the 18th birthday.
Right.
It's not, you don't.
Exactly.
It's kind of like when your child turns 26. It's not through their age of 26, unfortunately, but
For a lot of people.
But the night before, yeah.
So, again, as I said, I looked for cases. There don't seem to be any cases on the meaning or the procedure under 108B, but that does appear to be the only means by which appellant could have the ruling that she's actually appealing from, or the ruling she should actually be appealing from, to bring it before the court. I have nothing further unless the court has.
Gordon? Mrs. Thompson? No. Thank you, counsel.
Sure.
Mr. Berger?
Thank you, Honors.
There are a number of specific issues that I would like to deal with. I think the first issue pertains to what was most recently discussed, and that pertains to whether the hearing where the Commissioner reviewed Maribel's situation, whether he looked at the merits as to whether she had jumped through the necessary hoops, whether she had done the necessary treatment. And that does, the record does not suggest that that's what happened at the hearing at all.
Now,
We understand that. Okay.
but even recognizing that she had completed the program and done whatever else she was supposed to do doesn't compel relief from the order, right?
Correct, but that wasn't the Commissioner's analysis at all. He just flat out shot her down and said he does not have authority, and was not even prepared to entertain or move forward with the idea that he had that authority.
But as I understand the appeal in front of us, it's not that the Commissioner failed to exercise his proper discretion, it's that there was no basis for the original imposition of the requirement.
Yes, absolutely. That's an important part of it. To key into some of the specific issues that were dealt with regards to 108, one of the arguments was that application was not made to the presiding judge. That, I think, with regards to 108B, I think that overlooks the whole essence of the appeal in light of what Your Honour just mentioned. Our position is that for all the reasons that we stated in the brief and the reasons we've argued, the ineffective assistance of counsel, the statements that the trial judge made when he ordered the registration, the order is actually void or even voidable, depending on your perspective, and as such, that order in itself needs to be reversed. With regards to the psychosexual evaluation that the trial judge ordered with regards to Maribel, with regards to the initial sentencing and disposition, as the court is no doubt aware, the juvenile court has very broad discretion in terms of what it orders as a consequence for a juvenile. The purpose of juvenile court is rehabilitative in nature. It's supposed to help kids get back on track and improve. It's not punitive by nature. So the fact that she was ordered to participate in a psychosexual evaluation does not preempt the requirements of 118.
But counsel, there's a logical connection that you would order a psychosexual evaluation for someone who had a sexual issue in their crime. A judge wouldn't just order a psychosexual evaluation to someone who wrote a bad check.
Granted. However,
The rehabilitative purpose, that's the same in adult court. You have to have some rehabilitative purpose connected to the conditions of probation and what you make anybody do on probation. Why would a court order something like that if there was no connection at all to sexual motivation?
the connection to sexual motivation, the hoops that 118 required, those hoops were not met. So that doesn't mean that the judge didn't have that in the back of his mind and he wanted to look out for her best interests and the community's best interests, but those requirements specifically were not met. So for all the reasons that I've suggested, and I think the case of Espinoza is a significant one as well, assuming we're referring to the same Espinoza case, which is 229 Arizona 421. Factually, that case is pertinent because in that case he was adjudicated delinquent, registration was deferred, he aged out and was convicted of a non-sex offense in the adult court, and that judge ordered that he register, and a discussion is held down the line after he'd been to a DOC a number of times as to whether that was void or voidable, and ultimately it was reversed, which is what we're asking the court to
Is
do.
that the Division II case?
Yes, it is.
But the issue there was whether the trial court lost jurisdiction after it sentenced the guy to DOC, that he could not then impose the sex offender registration requirement when it wasn't part of the sentence. Am I talking about the same case?
I believe so. If I understand the facts correctly, the issue was whether the original imposition of the registration in the first place was well-founded, and whether that original order was void and or voidable, and whether the whole issue needed to be erased. But with all that, Your Honours, I would submit that if the original order or orders requiring Maribel to register are void or even voidable, if this court does not remedy the situation as justified by the fact of the voidness, the ineffective assistance of counsel, the statements by the trial court that led Maribel to believe she had a remedy other than appealing, she's left with nothing than a grave injustice. This court has the authority to remedy the injustice. We respectfully ask that you do so.
All right, thank you, counsel. We'll take this matter under advisement and issue a written decision. Court's in recess.